3, 4, 5, and 6. You pled true to all of those counts. You're on probation. The second-degree felony offense is theft of property with previous convictions with findings prior offenses were true. You were placed on that probation January 24th of 2024. I have received the pre-sentence report as well as there was one incident report from the jail page that should have been sent to you all, and also Mr. Coleman has also provided a copy of the court's sentencing hearing, a transcript from that original sentencing back on January 23rd, 2024. Has everyone had an opportunity to review all of this?
Yeah.
Are there any additions or corrections to that updated report?
Not saying on our
Yes, of course. So let me just, there's no agreement in this, correct? It's just open to the court. And, all right. Mr. Rojas, you may proceed.
Thank you, Your Honor. We're going to be asking for
no agreement, no safety net. When a case is open to the court, sentencing depends entirely on a judge's patience. And that patience has a history. This is where past chances start working against you.
probation. I know by looking at the PSI on paper, it doesn't look like that same so it should be given. Just to give criminal history, it looks like this criminal history is all some ways the judge you look at the allegations before it should be not to do with judge. And the reason for not applying to JCJ program. You have a comfortable with the background. He doesn't have a whole lot. He had a lot. Brother had an stop me out of the business. Even if he does want that page, I didn't offer his job. And I'm sure that one of the co-workers can point out to the comments about the court and not wanting to hear about you. More help with judge or you have.
I really don't, because here's the thing, Mr. Johnson. I'm looking back at your original pre-sentence report that when I put you on probation. I make notations on those reports, make highlights.
Notice the shift right here. The judge stops the narrative cold. This isn't about access to help anymore. It's about how many times help was already given. Once a judge starts referencing their own notes, the decision is already forming.
Those types of things. And I'm noting that in that report, you already, before this case, had gone to ISF and safety. And then on this probation, I sent you to ISF at the beginning of the probation. Is that correct or no? So you were on parole. I gave you a probation against Mr. Coleman's wishes and really against what looked like I should have. You went to ISF regardless of who. So you've been to ISF twice. Is that correct? You're looking at her. You've gone. Have you been to ISF once or twice? How many times? Okay, so you've been. But you keep getting. To do what? Because you've been to safety, you've been to ISF, and you went to ISF more recently, right?
Yes, ma'am.
Okay. You got right on probation. You didn't. You tested positive for cocaine after all of this time and all the different things that have been given to you and the opportunity that I gave you back in January of last year. You pled open, just open to me. I could have done anything. I could have sent you to prison for 20 years, 10 years, and I gave you an opportunity. And I said on that day, because Mr. Coleman printed it out for me, well, so how do I do anything other than what I said?
Asterisk this is the turning point. The judge reminds him this mercy was discretionary and conditional. When a judge says, "How do I do anything other than what I said before?" That's judicial language for, you crossed the last line.
Hey, we're not talking about anybody but you today. I'm sorry your mom's that old and that you haven't been around to be with her, but that's whose fault? It's not going to be my fault if you're not there. How about some personal responsibility instead of my mama's old and don't send me to prison? Go ahead.
On most recent term probation with the JCBI, we want to cases yet. We have 14th century, the appropriate for a whole new term.
Hold on. So if I'm reading this, I want to know when he went to ICE this last time. Parole sent him when. Because the way I'm reading is you were released from ISF and started JCDI August 6th of 2024. So I put you on probation in January, and between January and August, you went to ISF last year. Is that correct or no? Okay. So when was that? Went straight there. So I placed you on probation. You never got out. You went and got help at ISF. All right. Anything else? No. No. I still haven't done anything yet. So your response and how you act right now is going to go into what I do.
For the fact, the underlying offense, $50 dinner offense, $40 worth of merchandise. I would ask the court to consider lowering the rate to 5. Just because it can drop in your off, it doesn't necessarily achieve. That's what we recommend. These conditions not to be adoption.
Thank you. Mr. Coleman.
Sources and time and really resources not put out in with what we will lessons you guys did in the original and I provided you the transcripts just to remind the court essentially
And I do appreciate that because I do see a lot and I don't remember it all. But Mr. Taylor, do you have anything you want to say?
That phrase matters. Zero tolerance isn't emotional, it's procedural. It means relapse isn't a surprise, it's a violation. At this point, the prosecution isn't asking for punishment. They're justifying inevitability.
Do a lot of things in life, I was found I was very
Mr. You have. Well, it doesn't make any sense because you're saying, you've done a lot of time, and at some point, you either say, I don't like prison and I want to do better, but you didn't take advantage of the opportunities you were given. You're saying you want help, and we gave you help. Our parole gave you help. So you didn't even get out on my probation yet. You had ISF, a reminder of the tools that you had a long time ago. You had those things, and you got out, and you didn't take advantage of the opportunity that I told you. You better take advantage of it, because you're not going to get it again. You're saying the same things that you said. Please just give me another chance. I'm going to do better. Please send me to ISF or at safety. It's all the same thing that you're saying. And no one is setting anybody up for failure. Hang on. So what you're telling me is that when did you have back surgery?
8 years.
Okay.
They already do, yeah.
Listen. If you're throwing out to me that you had back surgery 8 years ago, then you are digging for everything you possibly can, and we're done with all that. I'm going to find that you previously entered your pleas are true to counts 1 through 6 freely and voluntarily. I'm going to find those counts true. I'm going to find sufficient evidence to find you guilty, and at this time, find you guilty of theft of property with previous convictions. I'm going to sentence you to a term of 12 years in the Institutional Division of the Texas Department of Correction. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you trial court certification that shows this was not an agreement. You do have some limited rights to appeal. You can talk to Mr. Rojas about that. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. Y'all need to sign that, and he'll give you a copy of it. Thank you. Thank you, Dan, for being here. Ms. Holmes on Demario Flucas. Hey, come back, Taylor. Come here. Let me tell you something. I still have jurisdiction over your case. So any disrespect that you show me right now, I can add years to that number. Is that what you would like to do? I do think it's fair. It doesn't matter that it's a misdemeanor. You keep doing it over and over. Go back with the bailiff. And you probably should keep your mouth shut this time.
And this is the last lesson. Sentencing doesn't end when the gavel falls. Respect still matters. The judge is reminding him that courtroom behavior can still cost him freedom. Even after 12 years, the system is still watching.